We've been talking for a little bit now about the investment powers of trustees, and in the previous video we were looking at the duties to disregard personal, ethical and political considerations. And in this video we sort of continue with this sort of general discussion about the power of trustees and investment powers and so on, to talk about standard and breach with regards to trustees. So let's get straight into this. And there's a quote from the case of Chapman, 1896, which says that there is no rule of law which compels the court to hold that an honest trustee is liable to make good loss sustained by retaining an authorised security in a falling market, if he did so honestly and prudently in the belief that it was the best course to take in the interest of all parties. Trustees acting honestly, with ordinary prudence and within the limits of their trust, are not liable for mere errors of judgment. So in other words, if you didn't do a good job, then that is fine. So trustees acting honestly with ordinary prudence and within the limits of their trust are not liable for mere errors of judgment. And knowing this general sort of rule is actually quite important to know when you're answering problem questions. So do bear that in mind. If you are a trustee and you're acting, within the trust rules, you're acting honestly, you're acting with prudence, then you cannot be liable for errors of judgment. That is the main pillar that you need to know about. However, there are cases that lead on from this. And we have this case of Nestle and National Westminster Bank. And in this case, the trust fund was managed by a bank as a professional investment company. Owing to a misunderstanding of the trust instrument, they adopted a conservative investment policy, which meant, according to the plaintiff, that the fund was worth very much less than it could have been. The Court of Appeal found that the failure of the bank to appreciate the breadth of its powers was inexcusable. However, as the claimant had not proved any loss, there could be no remedy. So just to reiterate, in this case, a man, Nestle, left a great deal of money under his will in the 1930s, money that eventually went to his granddaughter. And the granddaughter was outraged to find that her rich grandfather was only worth a modest amount of money. It was a lot less than she expected and a lot less than its real value from when the trust was originally constituted. Now, one of the reasons the trust fund had done so badly was because the bank did not use the full scope of its investment powers. It had left the money in safe trustee stock when in fact the trust instrument had given them the power to invest in potentially more profitable investments. And Dillon said it was the duty of the bank to acquaint itself with the scope of its powers under the will. It is understandable that the bank had doubts on a mere perusal of clause 13 as to its powers to invest in ordinary shares. It is inexcusable that the bank took no step at any time to obtain legal advice as to the scope of its power to invest in ordinary shares. So the trustee should have familiarised itself with the trust instrument, and anything they didn't understand they should have taken legal advice on. Had they taken the legal advice, they would have realised they were allowed to invest in potentially more profitable equities than they did. So there is a duty on the trustee to familiarise themselves with the trust, and more specifically in this case, there was a duty on the trustees to familiarise themselves with the scope of investments made by the trust. However, although the bank did an awful job, there wasn't any effect or loss, so it was okay. So just because you aren't good at your job, there wasn't any effect, so that is fine, okay? So this is important to realise when it comes to the standards that trustees have to reach and whether or not there has been a breach. We've also got this case of Lucking's Will Trusts from 1967. And in this case, two trustees, L and B, held 70% of shares in a shoe accessory company. Now, the defendant managed the business, and the defendant wrongfully took £15,000 from the company bank account, and he later went bankrupt, losing the money he took. The beneficiaries of the trust sued the trustees for breach of their duty of care. So the trustees had failed to supervise adequately the drawings of the managing director, resulting in the company losing £15,000. Now, Judge Cross held that the trustees had breached their duty of care and that they should have become involved in the company's management to prevent the misappropriation of the company's assets taking place. So the court held that there was a clear breach of duty of care by the trustees. So this case establishes a higher standard. So although the trustees were being incompetent, the court says there was another level here. The court said that when you own such a large portion of the business, you cannot just rely on someone else to take care of that business. If they had only owned 20% of the company and they were relying on the defendant to manage the company, the court would have been fine with that, but instead they owned 70%. So the court said when you own a greater proportion of the company, you have a greater reliability, of greater responsibility. So you need to actually be part of the board or management and get involved with the company. Now, what steps, if any, does a reasonably prudent man who finds himself a majority shareholder in a private company take with regard to the management of the company's affairs? He does not, I think, content himself with such information as to the management of the company's affairs as he is entitled to as a shareholder, but ensures that he is represented on the board. So it is very specific about ensuring you are on the board when you have such a large shareholding in the company. Okay, and the next case slightly modifies this, and we got this case of Bartlett and Barclays Bank. And in this case, a trustee company held shares in a family company. Under a new chairman, the company embarked on a highly speculative development venture which lost quite a lot of money. The court found that the trustee company was in breach of its duty in that it had not kept itself informed of the family company's activities and the risk to which it was exposed. So they were held liable for not exercising suitable care. They should have kept a much closer eye on what was happening in the company, and when they realised they were engaged in these sort of speculative investments, like property deals, they should have taken some action. Where a trust is invested in a private company, the trustees have a duty to ensure that they keep themselves informed of the company's activities. This may mean taking a seat on the board or receiving minutes of board meetings and management accounts. If it appears to the trustee that the company is taking a risk, which may be commercially acceptable but not acceptable to a trust, then they should take action such as selling the shares. So the court says that they don't believe it is necessary per se as trustees to go and get a seat on the board, but you have to do more than just sitting around. So this is a slight modification from the previous case we looked at, Lucking's Will Trust, which said you needed to get a seat on the board. So this case isn't quite as extreme as the Lucking Wills Trust case, but you do need to participate and make sure things are going okay when you own such a large share. The trustees must simply keep themselves informed of the company's activities. Okay, this may mean having a seat on the board. However, it could also include other things such as receiving minutes of board meetings and management accounts. Okay, so that was a really quick sort of side video about the standards and breach with regards to trustees. But I'm going to go straight back into talking about the investments and the powers in the next video, more specifically, before leading on to a discussion about the powers of maintenance and power advancing and other miscellaneous powers that are associated with trustees. But if you have any questions at all about this video, then please leave a comment below and I'll get straight back to you. If you enjoyed the video, then make sure you give it a thumbs up and subscribe to my channel. Thank you very much for watching.